Ladies and gentlemen, we will now begin the question and answer session. Anyone who wishes to ask a question may press star and one on their touchtone phone. Participants, to ask a question, you may press star and one at this time. The first question is from the line of Bhushan Trivedi, individual investor. Please go ahead.
Hello, thanks for the webinar. It was very insightful. I would like to get further kind of visibility on how this circular would affect the overall development of privacy framework in India. I think there was some discussion on it, but it would be great to have it clarified further in the sense that whether this circular already kind of makes a conclusion clear as to what the Sri Krishna committee would finally come up with when it comes to data localization.
Sorry, can you just identify who is speaking so we understand?
This is Bhushan.
Okay, so just say your name and your company name, so this helps.
Hi, my name is Bhushan. I am an independent practitioner from Delhi.
Okay, thank you. Maybe Aaron, you want to take it up since that was a time when we got kind of.
So, the Justice Sri Krishna Committee, in its white paper, published a chapter on data localization. Now, the preliminary views, taken by the committee, and obviously there were questions, for public consultation, and a lot of stakeholders sent in their comments. We see it in the report, which perhaps may come out next month by the committee with its recommendations. But the preliminary views of the committee was that not a lot of countries worldwide have implemented a data localization requirement. Very few have. And specifically for India, India needs to ensure that a fine balance is created between enforcement benefits on one side as well as costs associated with the requirement on the other side. And this is a balance that needs to be struck. And the best way of course, doing so is obviously a consultative process, with various stakeholders, involved in the whole, payments ecosystem. And what another point I was making earlier, I don't know if I got captured, is that this move by the RBI actually comes at a very critical time just before the report and recommendations by the Sri Krishna Committee are going to be released, right? So one is that this shouldn't affect, not only the report in a particular way, saying that, since it's more of a sensitive data and a sectoral point, to localize data on a sectoral basis, the RBI has already done it. But more importantly, this shouldn't serve as a cue for other regulators also to start falling in line. This shouldn't start as a trend, for other regulators to implement. What needs to happen is that the balance, as I spoke about, needs to be struck, and a constant consultative process with the relevant industry stakeholders to ensure that safety and security is obviously an important issue, but industry growth and innovation is obviously another important factor. So this consultative dialogue constantly needs to happen, rather than a sort of a premature law coming out, especially at this time before the committee report.
Yeah, can we have the next question, please?
Sure, thank you. The next question is from the line of Samant Kumar from Bank of Tokyo. Please go ahead.
Hi everyone, this is Samant here from Bank of Tokyo. As far as with my limited understanding of the circular, I just want to understand how to go about the service provider who is providing me the services for data storage and all. How to bind them, because they are the existing vendors and they are continuing with the license for years now. How to go about that, if anyone can.
So, Samant, very well framed question, and I think the entire industry is reeling under the same question that you have right now. I think the best way forward is to kind of approach the regulator with the problems that you are facing, laying out, what exactly is the background and, what implications will this cause. Probably we will have a softer approach from the regulators in times to come. Because I think, my conversations with RBI have been limited on this subject, but what I am given to understand is they have been receiving a lot of representations from various industry players, and they are willing to kind of give it a listening.
A reminder to the participants, anyone who wishes to ask a question may press star and 1 at this time. The next question is from the line of Ganesh Khare from DBS Bank. Please go ahead.
Good evening, all. This is Ganesh from DBS Bank. My question was on the aspect of whether the circular extends to all the banks. I mean, because it says while it has been addressed to all the banks and financial institutions and even cooperative banks, but it says that it applies to all system providers. And to my knowledge, I mean, all banks are not system providers under the Payment Settlements Act.
Yeah, that's a very good question, and you've actually nailed it. There are two legs to this, right? Though the circular one is addressed to, as you rightly said, it's to banks and payment systems, but the operative part of the circular, where the compliance issue is actually pointed out, it refers to system providers. Now, system providers are actually defined under the Payment and Settlement Act to means anybody who's authorized to run a payment system. And the definition of payment system is very wide. It not only covers payment gateways, but it actually says people who are involved in clearing and onboarding and concluding transactions. So there is a interpretation which can always prevail that banks to a certain extent assist payment systems in providing payment services and solutions. And I don't know, Shweta, you want to add to the angle the banks play, and that's why the extension of this circular could go to banks which are helping payment systems providers in providing services.
Yeah, I think, just to add to what Huzefa is saying, if you see, the circular is addressed actually to system participants and the banks. So the compliance confirmation will actually have to go from the banks and from the system participants, right? And that is why, there is a gray area, and that is why the industry is divided as to whether it is only for system participants to comply, or whether it is only for the bank, or whether it is for both of them put together. But then what about other intermediaries who are associated with payment systems? Does it imply to them as well? We are actually yet to see more clarifications from industry bodies and from the regulators to understand, what exactly it will mean.
And I think from a banking perspective, just to conclude on that, when the banks is using third-party service providers, assuming that the banks get covered under the definition of payment systems, the larger point which our colleague also raised earlier, one of the persons who asked the question, is that how do you go and bind your service providers, right? Now, do you start relooking at contracts? Do you start amending contracts, terminate contracts, sign fresh contracts which are more India-centric? So these are the questions, of course, the industry is, looking at the RBI for clarifications.
Yeah, and which is why the 6-month period also becomes really important, given that you'll have to rework so many processes, and that's why we're hopeful that the RBI will come out with some sort of clarification on this.
Thank you.
Thank you. The next question is from the line of Mosmi Thakkar from DR Joshi and Company. Please go ahead.
Hello, this is Kavit. I'm with my colleague Mosam from DR Joshi and Company. My question is that if a multinational company is already hosting a server outside, and because of this they are required to have a server copy in India, so if the entire data, whether a non-Indian transaction is also being eventually stored in India because of hassle-free compliance of hosting two servers, will that amount to a permanent establishment or a tax issues in India for that multinational company?
So I think that could yeah. Sorry, go ahead, Vaibhav.
I will take it, right. So let me understand your question. What you are saying is that if they copy, currently they are hosting outside India, if they copy the data in India, and whether while copying the data they also copy the foreign data, and whether having a foreign data by itself will become a permanent establishment, right? So while none of us are tax experts here on the panel, I will give you my immediate reaction. Simply by storing a particular data, one cannot be considered to be a permanent establishment. Though I am aware that having a server in India, there is a permanent establishment, and as a result, if you have a server in India, then that's considered to be a permanent establishment. Any revenue attributed to that particular server would be considered to be a revenue generated in India. But the difference between that portion and what you are talking about is it's just a mirror copy. There is no processing which is happening in India. There is the server data is not used; it's just stored, right? Because the data going to be used for foreign transaction is going to be outside India. Just having a storage will not, in my view, lead to any permanent establishment, right? If there was no storage there and if this data was actually being used, right? So instead of using, let's say, data in America or wherever else, they were only using Indian data, then there could have been chance that it could be considered to be a permanent establishment. But simple backup of data is unlikely to be considered to be a permanent establishment. Again, with caveat that none of us are individually tax experts, though some of my other colleagues are, but not us.
Thank you very much.
So there are no further questions in queue.
Thank you. Thank you everybody for participating and having a very interesting session. Maybe we can conclude the session if there are no further questions.
Thank you very much. Ladies and gentlemen, on behalf of Nishith Desai Associates, that concludes this conference call for today. Thank you for joining us, and you may now disconnect your lines.